Fox News alert, explosive new allegations in an infamous case of voter intimidation. A former Justice Department lawyer giving America Live a dramatic interview today, alleging politics and race were to blame for the decision not to pursue serious charges against members of the new Black Panther Party. The case beginning November 4th, 2008, with the presidential election underway. A voter catching on amateur video members of the new Black Panther Party wielding a nightstick, wearing uniforms, and issuing threats to voters outside of a polling station. Here are three witnesses, including some reporting by our own Rick Leventhal, on what happened that morning.
I'm just wondering why everybody's taking pictures, that's all.
Okay. I mean, I think it might be a little bit intimidating that you have a stick in your hand. That's why, you know?
Yes. Who are you to decide?
No, I'm an attorney. I mean, that's a weapon, so that's why I'm a little worried.
Who are you to decide?
I mean, I'm a concerned citizen, and I'm just worried that you might be...
And so are we.
Okay.
That's why we're here.
Okay, but you have a nightstick in your hand.
What?
I mean...
You got a camera phone.
People come to vote, and they come to vote in a peaceful atmosphere. They don't come to have somebody taking cameras and microphones and putting it in their face.
Well, do people come to vote with expecting to see someone with a nightstick out front? Was that...
Nobody here has a nightstick, and so I don't know what you're talking about.
I saw two armed, uniformed, threatening men blocking the door to a polling place, screaming rudeness at voters.
What was their intent?
I can't answer for what was between their ears.
What were they screaming, though?
I heard, well, one of them, for example, screamed, "Now you will see what it is like to be ruled by the black man cracker."
The Department of Justice went after those new Black Panthers, won the case, and was ready to talk sentencing, when suddenly, under the new leadership of Eric Holder, someone at the DOJ made the call to drop the case. And now, one of the lead lawyers who brought and won that case only to see it dismissed has resigned from the Department of Justice just a few weeks ago. J. Christian Adams gave us an exclusive television interview earlier this morning. He is also a contributor now for Pajamas Media. Take a listen.
Well, people were standing in front of the polls with weapons in Philadelphia on the day that President Obama was elected in 2008. The Justice Department brought a case in January under the voter intimidation statutes against the new Black Panther Party, the individuals who organized the deployment, and the folks with the weapons in Philadelphia with the polls.
Okay, and so the guy we see banging the baton, he was one defendant. The guy next to him, who was said to have been saying intimidating things, he was a defendant. The new Black Panther Party was a defendant, and the head of the party was a defendant.
That's right, all four.
Okay, and what was basically the heart of the case against them?
Yeah, this 1965 Voting Rights Act protects voters from voter intimidation. You're supposed to be able to go vote without somebody with a weapon shouting racial slurs at you like these folks were doing in Philadelphia.
What were they saying?
Well, they said you're about to be ruled by the black man cracker. They called people white devils. They menaced. They tapped their baton. They tried to stop people from entering the polls.
Is there any question in your mind that that violates the law?
No, nor anybody who worked on the case. It's the easiest case I ever had at the Justice Department. It doesn't get any easier than this. If this doesn't constitute voter intimidation, nothing will.
And you had not just that videotape, which we've all now seen, but you had witness testimony from some credible witnesses who were there.
That's right. Bartle Bull, he's a longtime Robert F. Kennedy civil rights activist, worked in Mississippi in the 60s. He said it was the worst case of voter intimidation he has ever seen in his 40 years of practicing civil rights laws.
So it was clear to you a case needed to be brought.
Slam dunk. I mean, nobody thought there was any doubt that this is the clearest case of voter intimidation that I've seen since I've been practicing law.
All right, so when the case was originally filed, who was at the top? Was it President Bush or was it President Obama?
It was President Bush. It was January of 2009.
Okay. So the case gets filed. You become the lead attorney on this case.
Well, but there were other attorneys working on it. The 5 attorneys in all worked on this case in the voting section. Chris Coates, Bob Popper, Spencer Fisher, and Grace Chung Becker, who authorized it. She was the Assistant Attorney General during the Bush administration.
And Chris Coates, his name is going to come up later. He was your boss?
That's correct.
And how many years had he been at DOJ?
He's a voting rights giant. He's been practicing voting rights law since 1976. He's literally one of the greatest voting rights attorneys in the history of the country, and he was really the lead on this case.
And there was no doubt in his mind this case needed to be pursued.
There was no doubt in anybody's mind. I mean, at least not the people who were working hard on the case, there was no doubt.
Okay, so you bring the case against these 4 defendants, the 2 guys we see on camera, the party, and the head of the party. And what happens next?
Well, you cruise along. The defendants didn't even appear. They didn't even answer. They just ignored the charges.
They didn't bother to defend it in any way.
No, it's like ignoring a speeding ticket. They just blew it off. They didn't show up for court. They didn't file any papers. They didn't do anything.
So you get something that's called a default judgment, meaning a judgment because they didn't bother to defend it. And the judge says to you at the Department of Justice, okay, write up an order and tell me whether you want to make this final, essentially.
Yeah, the court had already found and entered a default against the defendants. It was done. All we had to do is tell the judge what we wanted for punishment.
Okay, but instead of doing that, something changed at the Department of Justice. What happened?
Well, the case was dismissed on May 15th. All the charges were dropped against 3 of the defendants, and the final order against one of the defendants was a timid restraint.
So the only person who wound up facing any punishment was the guy with the baton, and instead of having a permanent injunction, which is what you guys wanted, never let this guy near a polling station and do this kind of thing again, he got what?
He's stopped from appearing at the polls with a weapon only in the city of Philadelphia and only for a couple more years.
And the other 3 defendants?
Nothing. They're dismissed from the case completely.
Okay.